and welcome back to the third webinar in our series of webinars. What I'll just ask everyone to do just for now is, for those of you who aren't speaking at all during the webinar or who aren't speaking right now, if you can just turn off your cameras and your microphones. That's just so we can try and ensure that we've got the highest level of bandwidth available so everyone can see what's going on. As I said, welcome back to you all. It's now just the core participants, so we're interested to have you on board and to have as a dynamic exchange as we can with a smaller group. The subject of today's webinar is also advancing ECHR judgment implementation within member states. And the main point, of course, is to hear about best practices from all of you. With that in mind, we've got two really interesting presentations coming up. The first will be from Mirela Budarovic, who's the Legal Affairs Advisor at the Office of the Ombudswoman of the Republic of Croatia. Now, Mirela will be talking about the Croatian National Council of Experts for the Execution of ECHR Judgments, which is another interesting example of how NHRIs can cooperate with other stakeholders at the national level and engage in early dialogue for ECHR judgment implementation. So that's the first presentation. Second presentation coming up will be from three participants from Greece. And they'll be discussing not only activities of the Greek National Commission for Human Rights, but also the more specialized racist violence recording network. And once again, I think that's going to be another interesting example of how NHRIs have used their mandate to push forward ECHR judgment implementation. Now, of course, the way that all of you do this will depend upon your individual situation in the country, your individual mandate, and of course, what you think is best in the circumstances. But it's nevertheless, I think, interesting to find these examples and to see what might be possible. With that in mind, we'll also encourage you to ask questions. So if you do have questions, we invite you to put them inside the chat, and that will be really welcome to see them there. But also, of course, do raise your hand in the sections that we do have for questions and answers. It'll be really welcome to hear from you during that period as well. So before we launch into the presentation of our first speaker, what I'll do is also quickly provide a presentation to you. Now, hopefully you can all see my screen. That once again is the agenda for today. So you'll see that there's substantial time for questions, so do get your questions in as soon as you can. And I think what I just wanted to do was frame today's discussion before we launch into it by once again going over these four different ways in which NHRIs can promote implementation of ECHR judgments. We'll be talking a lot today about points number 2 and 3. And before I ask our Croatian colleague to take the floor, I'll just talk a little bit about point number 2, highlighting the overall implementation record of governments and how NHRIs might be able to do that. I want to give an example actually of some of our work of the European Implementation Network. And this is actually something we did in Armenia in early March in 2020. And I think it's quite an interesting example of how NHRIs or others, anyone really, can promote the issue of how a government is doing overall with the implementation of their judgments and hold governments to account a little bit, encourage them to do better as a whole. So looking at the overall picture. So let's look at Armenia. We went there in March 2020. There's 21 leading judgments there. Obviously, each leading judgment represents an individual human rights problem that hasn't yet been resolved. So over half the leading cases from the last 10 years are still pending. That indicated to us that actually there's a bit of a slow process there. And overall, there's not a systematic implementation system that we would want to see. And the third point there is probably the most important. So we also saw that roughly half of the leading judgments had never been the subject of a government action plan or action report to the Council of Europe. Now that's a really important point because you know, if the government isn't submitting documentation to the Council of Europe, it really strongly indicates that actually there's not a systematic engagement with implementation, and that in itself is a problem. So something that we did then was we engaged in a couple of different things. One was a public event. You'll see the picture of it there. And that involved representatives from the government agent, involved NGOs. There's a judge on the panel, and there's a journalist. And really there was a public discussion of some of these issues and why the situation was as it was. But we also held sort of individual meetings with the government agent as well on a one-to-one basis, where we raised some of these issues about the overall record for implementation. Now, this is number of action plans and action reports for Armenia over the last 3 years. So obviously action plans, action reports are the lifeblood of things going forward and submissions being made to the Council of Europe. They represent activity, let's say, as long as they're done well on the implementation of judgments. So you'll see in 2018, 2019, only 3 going in. In 2020, 14, there's actually now 15. So that's the number of reports at least to the Council of Europe expanded by a factor of 5. And there's a couple of important things to say about that. We hope, we like to think that that's part of the result of the activities we did in the earlier part of the year, raising the overall implementation record, although we can't be absolutely sure. So there's one caveat to put there, and there's also another caveat to say, well, just because the government is submitting action plans, action reports, doesn't mean that things are really happening. You need to make sure that those reflect real activities in real life, and that's why Rule 9s are so important from NHRIs as well. But nevertheless, I still think that's an interesting representation of how raising these issues and raising the overall record of a government can help spur them into action in certain circumstances. Of course, it depends on the country. Armenia is, at that time was a quite straightforward place to do that, given its current government. So what are the key indicators? Let's go back to them again. It's the total number of leading judgments pending implementation. That represents the overall number of issues. Obviously, the average time that leading judgments have been pending, that's another really important thing to raise, because if the average time is quite long, that quite strongly indicates that, well, things are taking a long time to be executed, and you can put pressure on, perhaps on governments, or encourage them to have a system that works slightly better. I should say that there's certain countries within Europe where the average time leading judgments have been pending is about 8 years. And that's a really strong indication that the implementation system isn't really moving forward as a whole. A third important indicator would be the proportion of leading cases pending for the last 10 years. Once again, that somewhat shows what kind of scale we're looking at in terms of the number of cases that governments are working on and pushing forward and managing to close, and the number that they're not perhaps working so quickly on. And then the final issue is the one I raised of the proportion of leading cases that have never been subject to a government action plan or report. Now, just because governments submit a lot of action plans or reports doesn't necessarily mean that they're diligently fulfilling their obligations under the convention system. Turkey is an example of a country where governments do submit a lot of those plans and reports where actually they don't reflect strong actions on the ground. Nevertheless, I would argue that if you see a very low number of action plans and reports, that is another bit of a red flag about the overall record of the government. For the points 1 to 3 there, you can find all that data for your own country on our webpage, which is given in there. And number 4, we can provide that information to you on request, so please don't hesitate to do that. Ways in which NHRIs can think about raising these statistics. One could be in governmental working groups, lots of which we've been discussing, another which we'll discuss today. If NHRIs are on there, you can raise them on the agenda. Second, there's annual reporting. Third, public events like the one that I mentioned in the kind of public discussion, or we had a roundtable. Fourth, another possibility is having a conference and including people or government representatives in a more collaborative way. That's something that we had planned coming up in Armenia, until that was cancelled quite recently due to the events happening there. But that's another possible way. Ultimately, it's down to you. Of course, you'll be the best positioned to say what's most effective in your own country. So that's all I've got to say today. I'll stop sharing my screen and bring in our first speaker, Mirella. But perhaps you can come online and turn on your video.
Yes, I'm here. Hello, everyone.
It's
I'll
great
share
to have
my
you.
screen or
yes,
screen now,
go ahead and share your screen. Okay. And we'll go through with questions from me.
Okay.
And you can make your presentation.
Okay.
Of course, Mirela is Legal Affairs Advisor at the Office for the Ombudswoman of Croatia.
Yeah.
And through its National Council of Experts for the Execution of Judgments, Croatia offers an interesting example of NHRIs cooperating with national stakeholders. So perhaps, Mirela, you can introduce the Ombudswoman Office and tell us how the Council of National Experts was set up.
Yes, thank you. I just need to find out how to how to move this first slide to another.
Perhaps if you click
remote
on
control. Yes, just a moment. I'm not sure what is now. I'm not sure why.
If you,
yeah, great,
if you bring up,
great,
okay,
yeah.
fantastic.
Okay, thank you. Generally speaking, Ombudswoman of the Republic of Croatia is an independent state institution with a constitutional and a legal mandate to protect and promote human rights. It has a status A of Paris Principles and 4 mandates: human rights protection, national equality body, national preventive mechanism, and the whistleblowers protection. The Ombudswoman Office contributes to the implementation of ECHR judgment through opinions and also recommendations in our annual report. We monitor and analyze whether the proposed legislation is aligned with the convention and court's practice. And we also submit observations on draft of legislation during the public consultation process. So regarding the National Council of the experts, I can say that it was established in 2014 by the initiative of the, just a moment, it was established in 2014 at the initiative of the state agent of the Republic of Croatia before the court. It has 40 members and it is composed of the representatives of all ministries, judicial bodies, state attorney office, and of course our Ombudsman office. Basically, the methodology of its work is through a mailing list. Initially, a state agent office deliver a draft of action plans to all council members, and it also delivers the preliminary questionnaire to the council members. The preliminary questionnaire is a document which is composed of specific questions for a state body who's in charge for a specific judgment execution, and it is composed of specific legal issues which are stipulated in judgment as important legal issues. The state body who's in charge for the execution has the obligation to propose specific measures for the execution, for the implementation of judgment, general and also individual measures. And also it has the obligation to propose a specific time frame for the execution of that specific measures. Regarding our participation in the National Council work, generally we are monitor proposed action plans. I can mention that we have 1 representative in the council from the position of our office. And since now we are submitted opinion in 3 cases, 3 group of cases. First one was ECHR group against Croatia. That was cases concern discrimination against the applicants due to failure of domestic authorities to take the racistic motives into account behind the attacks on the applicant in such case due to his Roma origin, and on the applicant connection in Škorjanec, basically association the woman with Roma partner. That was a violation of Article 14 in conjunction with the procedural aspects of Article 3. Also, we submitted our opinion in the case Dolenec and Gladovic against Croatia. That was a group of cases concern a violation of the procedural aspects of Article 3 of the Convention on account of the failure of domestic authorities to properly investigate applicants' complaints of ill treatment by other prisoners or prison guards, which they suffered while serving their prison sentences.
And Maria, if I can jump in.
Yes, of course.
Beyond the National Council of Experts, Croatia has also
Yeah.
set up an anti-discrimination network.
Okay.
Perhaps you could mention that and describe the work of that.
Yes, we also have a permanent cooperation with other stakeholders. We are acting as some kind of bridge between national authorities and civil society organization. From the 2009, we act as a central equality body in Croatia through our anti-discrimination department. And in 2012, the office has established regional anti-discrimination contact points network, which was composed of 5 regional NGOs. In 2018, the Ombudswoman has signed cooperation agreement with members of the Anti-Discrimination Contact Points Network. And the network is now composed of 11 civil society organizations, which are selected after a public call. Beyond that, we also have the Council for Human Rights, which is established in 2013 by the initiative of our office. It has 8 members from civil society organization, media, academic institution, and also national minorities. And I think that is a very, very great example of how good cooperation can bring us some success in practice, because we are in daily cooperation with NGOs who are active in the field of anti-discrimination, such as Human Rights House in Zagreb and Center for Peace Studies and lots of other organizations.
That's really welcome. Thanks, Maria. And questions, or I was in the process of doing that, I think. So please do go ahead, Malaya, unless you have any more comments. We'd love to open up the floor to everyone else.
That's all I have to say. Maybe someone has
Fantastic.
some
Okay, so any questions for Malaya, or also in regard to my comments from earlier? We'd be really happy to hear from you.
Hello, I have a quick question.
Yeah.
As we heard, you have a council established and you are close cooperation with the government itself. And if there is such situation that your submission, your opinion is not taken into account by the government and they submit their action plan before the Committee of Ministers without taking your opinion into consideration, in that case, I think that you submit communications under Rule 9, yeah? So I wonder what is your experience about submitting Rule 9 communications?
Yeah, thank you.
Thank you.
We actually we don't have any experience in that field since we never submitted a Rule of 9. We are a state institution with not so huge capacity to deal with further process before the European Court. So basically our action is primarily focused on the action plans in the phase of their delivering to others institution in Croatia. So we are not we don't have capacity to dealing further regarding the Rule 9.
Okay, thank you.
There's a question from Leonie, which has come up in the chat. I'll come to that in a second. Maybe Maria, after you've done our fourth webinar which will be very much dedicated to Rule 9s. That will be coming up.
Be great.
Maybe you'll take an interest or capacity, who knows. Anyway, this question is, what does the Council of Human Rights do exactly?
Yeah, the Council of Human Rights has the advisory role. They advise Ombudswoman regarding the specific question which are relevant for broad society, especially from some specific questions like I don't know, free media or something like that. It depends because they don't have any permanent role. They advise ad hoc if something emerge, especially in the public space, which is important for our work. They put it on the agenda, and then we can consider which action we could take for further, for further process.
Okay, thanks very much to both. I just wonder whether there's any other questions to come in. Please do go ahead, turn on your microphone and start speaking. Okay. Maybe I could just ask one question myself, Malaya. Are there any particular cases you'd like to highlight as times where you feel like there's been a really good impact of this interaction with other stakeholders on the implementation of judgments?
I think that a case that I already mentioned from ECHR group that was this concerned discrimination. We gave lots of comments in the process of action plans compilation. Also, we are very active in that field. Since it's not my department, I'm not so involved in that case. But generally, I can say that I can read here just some things that they prepared to me regarding that. So we gave comments to state office, especially police, because it is clear that the legal framework provides a not adequate level of protection for victims of hate crimes. But the fact is that the rights of victims still quite illusory, since the authorities responsible for the prosecution and the prosecution of crimes still does not recognize that the hate motive is one of the ground for the implementation. That's why we are active in the field of education of police officers and also judicial academy. We think that is a good approach to give in the start overview of the importance of future recognize hate crimes as specific crimes in that context.
Thanks, Maria. There's a question that's just coming from David Janku. He says, hi, I wonder whether the setting up of the council and the anti-discrimination network was the Ombudswoman's initiative or rather a government or parliamentary initiative?
Yeah. The Anti-Discrimination Network was established at the initiative of the Ombudswoman Office. We first proposed 5 local regional network in Croatia, and we set up a cooperation with them in first stage, and then in 2018 we expanded that network, and now it is composed of 11 members, 11 civil society organizations.
Great, thanks so much, Maria. I think we'd better move on now
to
our next set of speakers, but thank you so much for joining us. It's hugely appreciated.
Thank you.
Okay, so I want to welcome now our 3 next speakers onto the webinar. So that will be Ms. Baka, Ms. Charakopu, and also Ms. Anastasopoulou. I'm really sorry if I've got those names pronounced poorly, but it'd be great if you can turn on your cameras and just say hello.
Hello. Hello.
Great. Thank you so much for joining us all. That's really appreciated. Now, we're bringing you to talk a little bit about the issue of setting up alliances and working with different stakeholders, once again, at the national level. And this example from Greece is quite interesting. So we've got 2 representatives from the Greek National Commission for Human Rights, Ms. Baka and Ms. Charakopu. And that organization initiated the creation of a racist violence recording network in 2011. So Ms. Anastasopoulou, who's the assistant coordinator of the network, will be able to tell us more about that. But I want first of all to give the floor to Ms. Baka for an overall overview of the National Commission in Greece when it comes to working domestically on ECHR judgments and their implementation.
Well, thank you very much, and thank you very much for the kind invitation. Well, the Greek National Commission for Human Rights is the Greek NHRI, accredited with an A status, and has a very broad mandate as regards the protection and promotion of human rights in Greece. We have adopted a general strategy as regards the implementation of judgments in the Greek context. And of course, when we talk about a general strategy, we talk of something much broader than rule number 9 submissions that we have discussed in detail so far. This strategy encompasses both domestic advocacy tools as well as advocacy tools that are used in the European and international context. As regards domestic advocacy tools, we're now developing a new dedicated website page where we explain the importance for the implementation of the European Court of Human Rights judgments in Greece. And we also offer a list of all judgments against Greece, as well as a list of judgments under simple and enhanced supervision. Through this webpage, we target students, young lawyers, public authorities, and a very, very broad group of people. We also raise awareness through public seminars. We have held a public seminar in 2019 at the Athens Bar Association regarding the implementation by Greece of the Choudhury case. Again, targeting young lawyers, public officials, even judicial authorities and the police. And this is within our educational mandate. We take the opportunity of hearings and discussions before the Greek Parliament in order to raise awareness as regards the implementation by Greece of the Choudhury case that happened in 2017 before the Parliamentary Committee on Equality, Youth and Human Rights. We also view several times domestic conferences For instance, in 2018, but also we use, of course, the standard tool, which is thematic reports, annual reports, and other publications, such as legal journals that we have used as a tool to promote the implementation by Greece of the European Court of Human Rights judgments. Now, we also use advocacy tools in the European and international context. Of course, it's a very, very important way to exercise political pressure because, as we said, at the bottom line is the implementation by the state of the judgment, right? So, of course, we have used rule number 9 submissions. We have used this tool twice. The one was in the Choudhury case. My colleague, Mrs. Harokopu, who has personally handled this case, and the submission will discuss in more detail, as well as Mrs. Anastasopoulou, who has handled the Sakir case, are better placed to discuss this tool with an emphasis on the engagement of, let's say, civil society and a variety of stakeholders that help in the production of these documents. Quite interesting because we have also used an advocacy tool in the international context that has, let's say, two facets. So the one is the UN special procedures. We have dedicated a separate section in our SADO report towards the Committee Against Torture in 2019, where we developed a bit the issue of the Choudhury case and the implementation by Greece of the Choudhury case. And I also had the opportunity in 2019, just before the COVID crisis, to deliver a statement before the UN Working Group on Business and Human Rights, the NHRI session, where I read a statement that had a separate section on the implementation by Greece of the Choudhury case. And also this had an impact, I have to say. So these are more or less the tools in general that we have so far used on behalf of the Greek National Commission for Human Rights. My colleagues, Mrs. Harokopu and Mrs. Anastasopoulou, will shed more light to the rule number 9 submissions that they have personally handled. Of course, Mrs. Harokopu on behalf of the Greek National Commission, whereas Mrs. Anastasopoulou on behalf of the Racist Violence Recording Network.
Thank you so much, Anna. I'd love to bring in Ms. Harokopu to talk a little bit about that exact case that was mentioned, the Choudhury case. Just to remind everyone, if you don't know the Choudhury case, it's actually a very serious case about prohibition of slavery and forced labor.
And trafficking.
And human trafficking, exactly. Perhaps, Ms. Harokopu, you can explain to everyone listening a little bit about the strategy that you developed to push forward implementation in that particular case.
Hello, it's my honor to speak at today's webinar, and I thank you very much for the invitation. MANOLADA case, as the so-called Choudhury judgment, is a leading case since it is the first case of forced labor and trafficking for the purpose of labor exploitation ever examined by Strasbourg court. As regards with the strategy we developed to push for the implementation of the judgment, I'd like to move on slide 3, please. Thank you. In the light of this landmark decision, the Commission decided from the beginning to closely monitor the case and the progress towards justice. Thus, the GNCHR, acting as a bridge builder between the state and the civil society, has committed itself to carrying out an extended consultation at domestic level. It started with the launch of 2 large-scale participation public hearings with domestic stakeholders involved in the fight against human trafficking. The hearings are actually a good example of the operation of our Commission on the basis of our pluralistic and polyphonic composition, which is comprised by 41 stakeholders. Our 41 members are nominated by NGOs, trade unions, independent authorities, universities, bar associations, political parties, parliament, and administrations. Both hearings have taken place in our premises, the first in November 2017, the second February 18. More specifically, we have invited representatives of the civil society, including Amnesty International Greek section, Greek Council for Refugees, Greek Forums of Migrants, the ADVRN, Medicine Sans Frontières, the United Nations High Commission for Refugees, NGOs, and also representatives of the competent state authorities to be heard before us and to discuss specific matters with regard to MANOLADA case on advance on assisting our work so as to be able to assess comprehensively the progress made by the Greek state. After the completion of the hearings, as is customary, the participants are requested to send their written contributions, answering specific questions regarding updated information, data, and statistics. Findings on results of the hearings are beneficial for the formulation of conclusion and specific recommendation to state authorities, also beyond national level. Subsequently, the Commission, making advantage of the results and recommendation of the hearings, we have prepared in MANOLADA case a roadmap on the implementation of the Strasbourg judgment, and then we handed it to the relevant state authorities and later on to the Committee of Ministers as a submission under Rule 9, which I will refer to later. I would like to add that at the same time, the Commission has raised awareness on the bigger issue of forced labor and trafficking of migrants through the initiations of parliamentary discussions and follow-up to MANOLADA, to Chodor case. And besides, the Commission is on a regular basis in communication with the competent authorities in order to provide advice and to promote appropriate and effective steps towards the full and immediate compliance to the Strasbourg judgment. Moving on, the next slide. Here we can see the impact of our actions at the European and international level. The Commission, while monitoring the developments at domestic level, we saw unfortunately that the measures taken by the state over the last years in order to combat and prevent severe labor exploitation phenomena remained limited. So we recognize the need to combine domestic advocacy efforts with Strasbourg-based tools in order to promote an essential compliance of the Greek state with its obligation according to the judgment. In this framework, we prepared and submitted to the Committee of Ministers in August 2018 our first communication as a Rule 9 submission. The communication has included the recommendation of both hearings with regard to the MANOLADA Chodor case judgment. 2 years later, in July 2020, while monitoring the limited progress in the compliance of the state with the judgment, we submitted a second communication to the Committee of Ministers as a Rule 9 submission, referring back to the whole content of our previous recommendation and examining the implementation course of each one in light of the new developments and evidence.
Thank you so much, Ms. Charakopoulou. I think now it would be really interesting to bring in your colleague, Ms. Anastasopoulou, to talk a little bit about the Racist Violence Recording Network. Welcome, Ms. Anastasopoulou. If you could just say hello.
Thank you for the invitation. Hi.
It's a pleasure. How lovely to see you. Now, whilst it's clear that the Racist Violence Recording Network has quite a large mandate, as we'll see, we consider this to be an interesting example of platforms that NHRIs can set up to support the implementation of ECHR judgments on specific cases. In this case, it's hate crimes. I'd just love to start off by asking you, you're coordinating the network. Can you explain to us why the Greek National Commission of Human Rights, together with the UNHCR, decided to set it up and what the present composition of the network is?
Of course, thank you for the question. The initiative for the creation of the Racist Violence Recording Networks was launched in mid-2011, as you said, by the Greek National Commission for Human Rights and UNHCR in Greece, following the rise of xenophobia in Greece and two major findings: the absence of an official and effective system of recording racist violence incidents, and the need for interconnection among civil society actors who dealt on their own initiative with victims of racist violence. Today, apart from the coordinators, RVRN is comprised of 47 non-governmental organizations and civil society bodies, as well as the Greek Ombudsman and the Migrant Integration Council of the Municipality of Athens as observers. Regarding the second point of your question, the common aims of RVRN are comprehensive indications on the qualitative and quantitative trends of the racist violence through the analysis of the incidents that RVRN members record, recommendations and to the authorities based on national and international human rights law, information sharing, and public awareness. Incidents are recorded according to a common methodology and based on a unified form, as well as following exclusively the direct contact with the victims and their testimony. Are the RVRN activities limited to the recording of the incidents? No. A quick look on the RVRN achievements during the last years give us a representative image of the total of its activities. Between 2011 and 2019, RVRN has documented through interviews with the victims 1,151 incidents of racist violence, and many victims were supported through the RVRN member services. 9 annual reports on trends are widely disseminated, and press conferences have taken place with pluralistic representation. Through the anti-racist legal reformation that took place during the last years, it was ensured a special protection status for victims and witnesses of hate crimes, empowerment of communities, international and European bodies such as FRA, ECHRI, OSCE and its office working on hate crime ODIHR, as well as UN agencies, recognize its reliability by basing their findings on its data and its conclusions. Golden Dawn, a neo-Nazist organization which was also a political party in the Greek parliament, and other individual perpetrators brought to justice. Just let me tell you that Golden Dawn was just convicted yesterday as a criminal gang, a criminal organization. RVRN was invited by the investigating authorities to actively contribute to the investigation of various criminal acts, while institutional recognition of its effectiveness has been reflected in the composition of the recently established National Council Against Racism and Intolerance under the responsibility of the Ministry of Justice, in which RVRN participates. Finally, very recently, RVRN submitted a communication to the Committee of Ministers of the Council of Europe for the supervision of the execution of judgments relating to the case of Shakir versus Greece, which is connected with the Greek anti-racist legal framework and its implementation.
Thanks so much, Gary-Falia. It would be really interesting to tell us more about that particular case and how you use the wide network of different organizations to really make a difference there.
Of course, of course. Regarding the RVRN submission and particularly the procedure, some RVRN members proposed to the RVRN plenary to submit a communication based on the rule 9.2. RVRN plenary approved the proposal, and the members that brought the proposal with me, the RVRN assistant coordinator, always, of course, with the support of the 2 coordinators, the Greek National Commission for Human Rights and UNHCR in Greece, prepared a draft submission which was presented to the plenary and was approved by the latter. With regards to the context of the submission, let me note that in response to the European Court's judgment for Shakir case, the Greek authorities have already taken a number of measures to prevent similar violations. In its submission, RVRN, while welcoming the positive developments in the Greek anti-racist legislation, developed its arguments on why it still considers essential that the Committee of Ministers includes the Shakir case under the enhanced procedure of supervision of the implementation. Our argument concerns mainly the identified barriers concerning the implementation of the anti-racist laws. In order to build this argument, RVRN was based on the following pillars. We analyzed the current reality based on the RVRN quantitative and qualitative data presented in its annual reports and based on the incidents that our members have already recorded. We used the findings from the monitoring of the RVRN and other cases on the basis of the investigation by the Greek authorities, the victim support and protection, and the recognition of the bias motivation during the court procedure. We updated the relevant information going back to the field, going back to the civil society, meaning to our members. Particularly, we used as a tool a questionnaire which was distributed to the 74 RVRN members in order for them to provide specific feedback on the implementation of legal provisions adapted based on the court's recommendation. We finally used the findings of the RVRN members regarding the recent frequent use of xenophobic rhetoric against migrants and refugees in the official political discourse, including by persons who hold public office, in order to highlight that the undermining of the efforts by Greece to improve the authorities' response to hate crimes is from inside and in high political level.
That's great. Thank you so much, Garifalia. Unless there's anything further you'd like to add a little bit more about in your presentation, perhaps I can open up the floor.
I don't know if you would like for me to say a few words regarding the domestic advocacy that we follow after.
That would be really interesting. Do go ahead with that.
Okay. Let me tell you, as I mentioned before, RVRN is member of the National Council Against Racism and Intolerance. All the Greek authorities and services involved on combating racism, as well as representatives of the Greek civil society, participate in this council. Given that NCRI is responsible, inter alia, to design the national action plans against racism and supervise the implementation of the laws against racism and the compliance with international and European laws, RVRN chose the NCRI environment to promote its advocacy, its domestic advocacy strategy. Hence, we inform the members of the Council for developments in the field related to the racist violence trends and the challenges regarding the implementation of the legal framework, recommending at the same time the needed amendments. And finally, we use specifically the submission under the Rule 9.2 and the included recommendations in order to ensure that the needed changes will be included in the upcoming National Action Plan. Thank you.
That's very interesting, actually. That's very interesting to hear how the direct link between the organization and the action plans of the authorities. Okay, let's open it up again, as I said, to questions. It'd be really interesting to hear from any of you. First of all, for questions about the presentation from our Greek colleagues.
I have a question, please.
Go ahead, Tamar.
My question is to Ms. Baka. Unfortunately, I forgot the name. So she mentioned that they are using human special procedures and they submit schedule reports, and they use these schedule reports in order to push government to implement ECHR judgment. I would like to hear a bit more how they use these schedule reports and how they draft the schedule reports and how they use this tool to push implementation of ECHR judgment. Thank you.
Thank you very much. I think I heard the question because there were some music behind. So that took place in 2019 we prepared
Anna, I'm so sorry to interrupt you. Maybe you could just repeat the question as you heard it, because I think some colleagues didn't hear the question. So,
okay.
Tamar, don't
Can
worry.
you hear me?
It's okay, Tamar. We've got the question, but maybe someone's saying in the chat, just Anna, if you could repeat the question you heard, then that's the best way forward before answering it. So, Tamar, don't worry. I think we've got it.
Okay.
The microphone, please. As we have a lot of background noise. Yeah, thanks. So the question was whether I could develop a bit more how we used the shadow reports in order to promote, let's say, to exercise political pressure as regards the implementation of judgments, the European Court of Human Rights judgment by Greece. And I will bring the example in 2019, what we did is in our shadow report, in our submission to the Committee Against Torture, that was in June 2019, we prepared a report in response to the list of issues with regard to the report of Greece. And within this report, we dedicated a separate section. Within this report, there are different sections, thematic sections. Within the thematic section of forced labor and trafficking, we of course had to mention the Chaudhry case. So we took the opportunity, and I think that this is a tool, this is a very important tool to use even the UN fora to exercise political pressure that will return back to the state. And we used that, as far as I know, at least twice. The one was with our shadow report to the Committee Against Torture, and the other case was to the UN Working Group on Business and Human Rights, where we read a statement where we also referred to the Chaudhry case. And we consider that this type of political pressure is very important as well. I don't know whether I answered the question.
Thank you so much, Anna. I think that was
Thank
clear.
you.
Tamar, any follow-up?
Sorry, can you hear me?
Yes, go ahead.
So in this shadow report, you evaluated what are the necessary general measures for the government to adopt in order for this judgment to be executed. Yeah, it's my understanding correct? So what were the main findings in the shadow report, what you mentioned there?
We mentioned briefly, let's say, it's not, well, the Chaudhry case, and although I think Katerina is better placed to discuss it if needed, I think it's not really the gaps in legislation, but really the implementation and the role of investigation authorities that, let's say, the fact that they did not work effectively on this judgment that brought the condemnation of Greece. So this is what we described as a shortfall. So we did not really, I think, insist on the legislation, but what really happens in the Chaudhry case and the practice or the lack of practice from the part of public authorities. And it's something that we thought, and I think, I'm not really sure if in the conclusions of the committee it refers to the Chaudhry case, but I think it is really important because it would bring an impact and force, let's say, indirectly the state to take into account the fact that it has not really effectively implemented the case in the Greek context.
Thanks so much, Anna. I hope.
Thank you. It's clear.
Perfect. You're making me hungry, Tamar, with this the sound of the cafe or the restaurant in the back. Okay. Any other questions for anyone for our Greek colleagues, or indeed for any of the other speakers today? Please do go ahead and let us know. Just wait a couple more moments. Okay, I don't hear any other questions coming in, so I think for that reason it's time for us to wrap up. Thanks so much to all of our speakers today. It's been really interesting actually to hear more about the different links between your organizations and the different stakeholders that you've got in your own countries to push forward implementation in the experience of EIN, it's always the case that when organizations work together with other groups or other entities, it makes a huge difference to pushing forward ECHR implementation at the national level. So it's been very, very interesting to hear how that's worked in practice, particularly in regard to hate crimes in Croatia and Greece. So thanks very much to Maria, but also to, of course, Anna, to Katerina and Garifalia. Moving on to the next webinar, that will take place on Thursday, the 22nd of October. It will be very interesting because it will focus on Rule 9 submissions and the drafting of those to the committee ministers and the implementation monitoring process here in Strasbourg. There's two really important things to remember before that session. First, it'll be very crucial to watch the video by Nikos Soteropoulos. Nikos, you've seen already, he's one of the heads of division at the Department of the Execution of Judgments. That video will be about the do's and don'ts when writing Rule 9s. We'll put that right online right after this webinar. And I think that will be a very good guide of things to bear in mind when making your submissions to the Council of Europe. The second thing to bear in mind before the next webinar is to send us your feedback or send us your information about the cases that you're working on prior to the webinar. That will allow us to do some preparation, answer your questions, be able to have a richer interaction, hopefully then, and it'll give us the best opportunity to help you the most in what you're currently working on. But I think that's everything for me today. So thanks again to everyone. Thanks for your attendance. Thanks particularly to our speakers. And I was about to finish, but I've just seen a message in the chat. Okay, sorry to hold everyone. I feel like a teacher who's just received a question just before everyone's left the classroom and is holding everyone back. But there's two questions that have come in. I hope you don't mind if I just hold on to you for 1 second. One is from Chrysanthi.
I'm sorry. I'm so sorry to interrupt, but I'm not writing these questions.
Oh, really? Okay,
yes.
that's interesting, Chrysanthi. Well, someone's written the question, and I hope you don't, well, we'll pose the question anyway, regardless of who's put it. I hope that's okay with you, Chrysanthi. And I think it's how do you coordinate within the NHRI on Rule 9s and national advocacy? So maybe some of our Greek colleagues can answer that exactly. I think the question is, how do you work between the lawyers writing the submissions and the advocacy sections? How do you coordinate?
I don't really understand the question, to be honest.
I think the question is, unfortunately, we can't bring in the speaker because someone's masquerading as Chrysanthi. I'm sure it's someone just with accidentally the wrong name.
Yeah, this is Catherine. I asked the question. Sorry, there must be like a technical thing. Also, sorry for asking the question. It appeared late, I saw. Sorry for that as well. So yeah, I was indeed a bit wondering, also because of the comment of Mirela before that, for example, in the Croatian institution, they seem to have not enough capacity, to follow up the national advocacy with Rule 9s. So maybe I thought it could be interesting if you can explain a bit more how you organize within your NHRI, the interlinkages between domestic advocacy, Rule 9 interventions, and whether you think this really requires a lot of capacity. So yeah, I thought that could be interesting. Sorry to all for holding you here, but yeah, thanks.
I don't know whether Mirela would like to take the floor.
Exactly, we don't have capacity. I think that Katrine asked, how do you manage to coordinate in your institution, if I understand correctly?
Yeah, I think that's right, Anna.
Yeah.
I think the question is how you manage to coordinate between the different branches of your institution.
That was exactly what we presented about the domestic level and international level and the different tools we use, such as the public hearings, the parliamentary discussions, communication with state authorities, and then findings and conclusions, and then we formulate either a report or a communication in MANOLADA case, for example, we first prepared a report regarding the situation in MANOLADA and the implementation of the compliance of the Greek state with the judgment, and then we worked together with the execution department of the Council of Europe, and we prepared a set of recommendations as a roadmap, and that was our first submission as a submission on Rule 9. And then we continue to follow the developments, we were examining the measures, individual and the general measures, and we prepared a second communication reflecting the progress made by the Greek state. And we also submitted as a Rule number 9 submission.
I hope that answers the question. I think we'd better tie up now. I don't want to hold people back longer than you expected. Katrin saying thank you in the chat. So thanks again for all of you for taking part, and I look forward to seeing you in the fourth and final webinar.
Thank you.
Pleasure. Thank you.